So the first time you're arrested for OUI in Maine, it's, assuming you've never been in trouble before, it's a pretty scary situation. You're pulled over, it's late at night, you've answered some questions from law enforcement, you do some roadside field sobriety tests, they tell you you're under the influence, they cuff you, they stuff you in the back of a cruiser, and they take you either to the county jail or the local PD. When you've been arrested, they're going to give you a breath test. And after taking that breath test, assuming you blow over the legal limit, or if they think you're under the influence of marijuana or prescription medications or illegal drugs, they're going to ultimately summons you, which looks like a traffic ticket, for operating under the influence. Bail will likely be set. Usually in most cases, it's PR bail, which means you pay $60. PR stands for personal recognizance. That means you're swearing by your word. You'll show up to court. And after that arrest, you'll sometime early in the morning be released. And now you have to deal with the fallout from that arrest. That means you're looking at a license suspension. You might be looking at jail based on the breath test result. Things can get markedly worse. You could be looking at a loss of your employment, depending on what you do for a profession. So a lot of things can happen on a first offense OUI that people haven't anticipated, even things like travel. For example, if you have a vacation planned for later in the year to go to Canada, you're going to go to Quebec, go see old Quebec City, that might not be possible just by virtue of being charged, because certain countries like Canada treat a suspension for OUI, not even a conviction, as if you were convicted in that country, and they will bar you or prohibit you from entry. So there are a lot of negative consequences that will flow just from the fact that you were arrested. So there's two ways that the state of Maine can take your license, assuming you have a Maine driver's license. If you don't have a Maine driver's license, they cannot suspend it, but they can suspend your right to drive. So you can be suspended by our Bureau of Motor Vehicles, we call that the BMV, following a hearing. Or if you're convicted in criminal court, you would be suspended. So on a first offense, the mandatory suspension is 150 days. Let's look at this scenario a couple different ways. Number one, you are suspended following a hearing with the Bureau of Motor Vehicles. That suspension goes into effect, and for 5 months you can't drive. Let's say things go really wrong on the criminal case, and later you're convicted. You've been driving, you were suspended for that 5 months, now you're driving again. You go back to your final court appearance, things didn't turn out the way you hoped they would turn out with your attorney, and you plead guilty or are convicted, found guilty following a trial. The court will now impose its own 150-day suspension. Assuming that you've fully served out that 150-day Bureau of Motor Vehicle suspension, the court suspension will run concurrently. It'll be backdated to the Bureau of Motor Vehicle. But if you had, say, for example, a work license privilege after the Bureau of Motor Vehicle suspension, so you could drive back and forth to work, the time spent on that work suspension privilege does not apply toward the court-imposed suspension. So there's a lot of subtlety and nuance here that experience and time and practice, someone like I have, can explain. But it's fairly complex, the interplay between the Bureau of Motor Vehicles and the criminal court. And if you have an out-of-state license, now you're adding another layer of complexity, because now what you're concerned about is the loss of your license in your home state, not so much Maine. So frequently we get a question, I blew under the legal limit. Don't they just have to dismiss it? And the answer is no. Well, really the answer might be maybe. So the law in the state of Maine is there's a presumption that if you blow a 0.08 or higher, you are per se under the influence of alcohol. If you blow between a 0.06 and a 0.07, then there is no presumption that you are under the influence. If you blow below a 0.06, there is a presumption that you are not under the influence of alcohol. But what happens when you blow under a 0.08? Do they just say that's the end and we'll dismiss the charge? No. Oftentimes what happens is law enforcement, they arrested you because they thought you were under the influence. And, oh, wow, you didn't pass, you passed a breath test. Well, I, as a law enforcement officer, couldn't possibly be wrong. So you must be under the influence of drugs. Maybe it's a prescription medication, maybe it's marijuana, maybe it's illegal drugs, but I'm going to get to the bottom of this, and I'm still going to charge you with OUI because I'm going to bring in a drug recognition expert if I'm not one, and I'm going to put you through another series of tests, and I'm going to ask you some questions, and ultimately I'm going to determine that you're under the influence of drugs. So just because you blew under the legal limit does not mean they cannot charge you with an OUI, either because you're just under the legal limit and there's no presumption, or they believe you're now under the influence of drugs. The charge is still the same. It's an OUI. Here's another question I get all the time. Shouldn't I just go plead guilty? I'm not going to jail. I can deal with the 150-day loss of license. It's not going to impact my profession at this time. What I tell people is the best way to avoid a second offense OUI is to avoid a first offense conviction. The penalties on a first offense, they don't seem to be that big for some people. Maybe there's no mandatory jail. You can get an ignition interlock device or some other way maybe to get back and forth to work. You can maybe make things work. Maybe your home state, if you're from out of state, isn't going to impose a suspension if you have a conviction here in Maine. Highly doubtful, but perhaps that's what you're thinking. But here's the problem. 7 years from now you've got this great career, you've got a family, things are going well in life, and now you had a few too many drinks with your coworkers, and you get pulled over, arrested, and you blow a .10. It's a second offense. And that first offense, had you fought it, could have prevented this from now looking at a 3-year loss of license, a mandatory minimum, and I say minimum, mandatory 7 days jail. That's a huge difference between what you're facing on a first offense versus what you face on a second offense. And nobody, including the person or people watching this video, go out with the intention of driving under the influence that night and picking up a DUI or an OUI. But that's what happens. And if it happens a second time, it is a significantly worse place to be. So should you fight a first offense OUI? Absolutely. If you've been charged with a first offense OUI, my name is Attorney William Bligh. If you've been charged, just think OUI, better call Bligh.